Greetings, Moors, greetings, Moors. I know that there are no one on. Oh, here we go. Islam Moors. This is class two, really. Class two on false imprisonment. I guess what I want to start off with is why is this class important? This class is important for a number of reasons. The main reasons is to know the law. So Moors as well as Albions, as well as anybody else that is domiciling or residing in any of the so-called 50 corporate states, whether it be through Moroccan statehood or it be through these Moorish American organizations. And even if it's one of those, you need to know the laws that are governing at the present time so you don't fall prey to so-called racial profiling. I'm going to start doing some blogs. I'm going to start doing some broadcasts to kind of bring awareness to what our people really, what I feel, obviously it's what I feel, people should be looking to participate in. It's about community activism. It's about knowing your laws, and it's about getting knowledgeable of international law and what we as Moors need to do to put our political footprint back in international law, back in an international community, as well as in regards to a political platform. Because no, we're not United States citizens. We never were United States citizens. We're just a protected classification of individuals who were stateless and under the jurisdiction of United States of America. We're viewed as privileged proteges or quasi United States citizens. I mean, literally, because our people don't have a political platform outside of the United States, they have to participate with the United States as so-called citizens because you don't have a status outside of that. And pursuant to international law, as well as pursuant to the different conventions that were established, you can't be stateless. So you'll be protected under whatever government, intergovernmental organization, yada, 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 that is controlling the territories that you currently domicile in. What do I mean when I say these things? Going forward, there'll be another class added for the time being in regards to international law. It's to get our people knowledgeable or at least competent to a degree on what is international law. What does it mean to us? Why have we not been on that platform outside of our participation as so-called quasi United States citizens? Now, that being so, this class is to bring awareness as well as understanding to our people so they can start getting engaged in the right fight. We can't keep sitting here talking about we want this, we want that, we need an economic base. We keep getting violated when we're not putting the energy in place to stop that from happening. So without further ado, again, this is the second class of false imprisonment, arrest and false imprisonment, because we have power, just like everybody else has power. We have power to make sure whatever jurisdiction that we are in, whatever platform that we are participating in, whether it be whatever platform that we're knowledgeable at the very least in regards to the platforms that we are participating in. So that being said, I want to bring up the website. Please let me know as I navigate. Sometimes I am not aware of what you guys are seeing versus what I am seeing. So I just wanted to make sure I put it up there for everyone to see. So I'm going to start sharing my screen and try to share. I guess I'm going to have to start hold to select multiple. Okay. Okay. So hold what? Control to select. Okay. So I kind of want to push all of these, so it's going to share whatever screen I'm particularly on at that particular time. So this is the screen I'm on right now. This is our training screen. I'm sorry, our training website to have a platform as well as information out there for Moors to get competent as it relates to international law. But this particular class that we're dealing with now is false imprisonment. I am going to start a class on Tuesdays, which is going to be international law, because our people need to stop playing around. We can't sit here and ask for independence and we're not willing to read the documents that we need to read to become competent in international law, so you can make a proper claim in the territories that you domicile near. That being said, I have sent everyone a copy of the revised, this is a revised version of the treaty on arrest and false imprisonment. This treaty was originally done, I believe, in 1994 by the author Charles A. Wiseman. Charles A. Wiseman created this treaty to give people information as it relates to your rights and what the obligations all governmental employees, regardless of the capacity and whether or not it is an office elected into or appointed or an employment position within a specific governmental organizational structure. So this is a treaty that I actually kind of worked diligently hard on in regards to making it functional, turning it into a course, as well as making sure that the things that needed to be highlighted in it was highlighted in it, as well as making sure I provided question and answer sessions, multiple choice questions, and just to make sure you're learning what you need to be learning from this course. At the close of this course, what you're going to be able to do is know when you've been violated, when you have been unlawfully arrested, unlawful searches and seizures, and what constitutes an arrest, what constitutes detainment. What are these things? You're going to learn that we haven't been told a lot of things. We haven't been given the information on a lot of things. And because of that, that's why we're dealing with a lot of the things that we're dealing with as so-called indigenous people, Aboriginal indigenous people. If you're claiming an actual international status or a national state status, a Moroccan national, whatever it is you identify as, until those consular court orders go out to the United States of America in regards to the Moroccan states that have been established, we have to toe the line. And you have to make sure you know while you're in this platform how to identify when you've been violated and you have been injured by agents of all levels of government, as well as just regular old people. False imprisonment does not just only amount to an elected official or a patrolman or anybody. It could be anybody who is unlawfully detaining you, who doesn't have the authority to detain you. What am I saying when I say these things? What I'm saying is eventually I'm going to have the board over here and I'm going to be able to turn it sideways so you can see the board over here, whereas I can start putting up the documents and putting up information so you can be engaged as it relates to the things that I'm and the knowledge that I am imparting on you. Now, the updated treaty is located on the website, but like I said, if you go down on the website, you go down to, like I said, I'm going to be updating the website simultaneously within the next coming weeks. So please make sure you are always checking to see what the updates are, because my job is to make sure we are competent Moors. We are competent and we know what it is we are required to do as Moroccan nationals. So what I mean to say is right here, if you see, this is the updated version of the treaty on arrest and false imprisonment. I emailed a copy to everybody that was on my email notification list yesterday. When I finalized this document, it was either yesterday or the day before, can't really recall, but I took months, I'm gonna tell you months, because I was working at the time to finalize this document, and I had some free time and I was able to kind of expedite it. So there's a lot that's going to be on here. I'm going to remove this section because all of the information that was on this section is now in the documents within the body of the documents. Now I have the version with all the answers to all the questions, but you guys have the version where you have to kind of, and it's definitely recommended that you print the whole thing out, double-sided, single-sided. I'm a double-sided person because I don't want to have more paper than I need. So I would say print this out, double-sided, take it to your local UPS store, Staples store to be bind it up. So once you bind it up, this is your go-to. You can do your homework in here. You can add a couple pages at the end so you can have notes at the end of it. So this will be your notebook in regards to false imprisonment, because the realities are either we have or we known of an individual who's had this happen to them, who's been in prison falsely. And we're going to go through what all of these terms mean. There are previously recorded classes where we went over this exact same document, and I did do a good job, I think, in doing it. But at the end of this, you'll be able, Islam, at the end of this course, you will be able to file, draft up your own case, a claim against a individual or a group of individuals who violated you. So this is my mission, y'all. This is my goal. This is my mission. We get racially profiled because of our ignorance in law. We get violated. They violate our rights because most of our people are unaware of their rights. And then we'll contract with an attorney who is not going to put the argument up that needs to be put up in order for that case to be dismissed. Now, here's the thing. Even if you're guilty of what it is that they're saying that you're guilty of, they still have to follow proper protocol. They cannot get around proper protocol, which would be another word for due process of law, the law of the land. All of these different terms mean exactly the same thing. You have rights. They cannot infringe upon your rights without authority. Policy enforcers, federal agents, sheriffs, any so-called code enforcers, any so-called, they call them officers of a court, have no authority outside the order that is granted. What do I mean by orders that have been granted? Meaning, if a judge sends you a warrant, that judge is saying, look, bring this person to court to stand for these charges that have been filed against him, whether it be filed through a so-called agent to the same, they have to follow protocol. They can't come in and arrest you unless there are two, as you're going to see, unless there are two specific things. There are two elements that have to be met before they can do anything against you or anything to you, because outside of an order from a court judge, they do not have the authority. We're going to realize what those things are. And the crazy part about it is every policy enforcer, every sheriff, every FBI agent, every security guard of any so-called corporate venue should be watching this video, because you need to realize as well, you are causing injuries and you are causing a claim that where remedy will be sought against the violations. Now, what are some of the things that people do when they're filing a claim against an individual? And this could be your darn husband, it could be your darn wife, it could be your darn neighbor, it could be your mother, it could be your father, it could be your children. If you are violating my rights and you don't have any provocation, I didn't provoke it in any kind of way, you're violating my rights. And you can seek remedy for that violation. And the more we start knowing the law as Moors, as so-called even Black people, if that's still how you're identifying, or white people, there are rules. You need to know the law. You need to know the law so they can stop being the way that they are in the streets. I understand there's crime. I understand that people have to atone for for things that they do that is an injury to another. There's processes that have to be honored, that have to be followed for that to be legitimate. Now, give me 1 second. I am going to put this on. I have to plug in my laptop is dying on me. Give me a second, John. So I gotta plug it up, make sure I don't die. Or my computer doesn't. Is it plugged up? Yep. All right. So where was I? Islam. So I was at the treaty. Everybody got an email of the treaty. Everybody got the copies. I've already seen individuals send me screenshots and pictures that they printed them out. I would definitely bind it up. Islam sincere. Love the hair. I ain't seen you in a decade. Spend a minute, bend a minute, like the hair growth. I don't think you had hair before. I don't think you had any hair.
All the time, but I'm back.
Looking good, looking good. So at any rate, let me tell you, I have been going through this document from the forward to the backwards. I think everybody on this call has a situation where, or at least a multiple situations where they could file false imprisonment claims. And you can get at least 25, 50, or depending on what the injury was. And realizing that we're the only ones be sitting in jail and they didn't even have the lawful authority to do anything to us. And if we had the appropriate argument, we should have been able to not only get that case dismissed.
The law is basically tell them what they
Who's talking? Hold on, Arnaz. You got to kind of let me. Islam.
I didn't even know.
So, a lot of cases would be required to be thrown out, even if they didn't do it at the magistrate's level, because they want to be arrogant and they want to force an attorney on you because they don't want to speak to you directly. But at the same time, what I always find in any so-called lawful venue is that the only way they try to stick you is by not following the rules of court, by not following the proper protocols to file a motion, file a petition, because they try to ignore your request by the sheer fact that you didn't file it the way it was supposed to be filed, because you're asking the judge to hear an argument that is essential to the case, right? So knowing that we've all been steered in the wrong direction and we're all coming to grips with that nonsense, but the beautiful part of it is now we know. Now we know how to navigate. Now we know what it is we need to be learning. Now we know what to do. I'm trying to tell you, these classes are going to be very beneficial, as well as the international law class, because our people have been fighting against the tide, literally against the tide. And I'm not going to sit here and say that this wasn't intentional. This wasn't intentional by our people who were getting paid to keep us in the same position, right? So my job, as I learn and as I grow and as I get informed, it is my job to push it on to you, right? It's my job to clarify certain mispresentments. So I guess before we start really getting into the topic of discussion, because our first official class was last week, where everyone was given chapter 1, which was the introduction, and chapter 2, which was the definitions of false imprisonment. That was the homework that was given last class for you guys to be prepared to discuss in this class. And then this updated treatise on false imprisonment was emailed to you guys once it was done. So I'm not sure if anybody actually had a chance to review the first 2 chapters, and if you actually had time to get any of the homework done. So I'm going to yield for some comments, questions in regards to if anybody is even ready to discuss those 2 sections, or are we going from scratch? Because I can literally, I know this stuff backwards and forwards. I can speak to it. And I've already drafted up 2 affidavits that you could literally file tomorrow, as long as you just replace that information with your specific information. You can literally go file it. So with that, I yield. Are there any questions in regards to what was just discussed?
Yeah, I'm just getting back in tune. I'm just doing the knowledge. I just got an email, so I hopped on. I don't know what's going on though, but I'm gonna find out very soon.
Islam. Thanks for your honesty.
Islam. It's Armin Arnez.
Islam Arnez.
So I've been heavy studying this law, right? So most of what I'm learning as far as when it's coming to law is that they're not even operating they're not even on the same page we on. Like, I went to a preliminary hearing, right? They don't have no stenographer in here, so they're operating hearings in a private. You get what I'm saying? Mm-hmm. Keeping it away from the public, because all hearings are supposed to be for the public, because their constitution was put in place to keep them in check. It has nothing to do with us, but it was put in place to put them in check.
Let me interject for that. Go ahead.
Huh?
No, go ahead.
Even when you present the actual law, because they're operating as administrators. So they're operating under statutory
but answer your question. Why are they operating as administrators? Clarify what you're saying in regards to them operating as administrators.
Because they're enforcing statutes and codes. They don't operate as you operate as administrator when you're enforcing statute and codes. That's where the pin hollow.
But I wanted you to be a little bit more. I wanted you to go into authority, because the one thing
they don't have no authority.
Hold on. The one thing I want our Moors to be is realistic to reality. We've been playing belief systems for far too long. And this platform is going to challenge you. So please, Moors, put your big girl and big boy pants on. And don't get emotional about the things that I challenge you on. Because this challenging, not only for you, is good for me. Because when you get into platforms that are talking about different things, you got to play the game. So what do I mean when I say administrator? Because you took it to a different level, and I wanted to stay where it actually is.
Well, no, I mean, it's all in the same pot, because at the end of the day, it all deals with false imprisonment, how they're acting, the thing they're enforcing bill of attendance they're enforcing stuff that don't even exist, because they operating under amorality, but they don't call it amorality. They either say
you talking about admiralty law? Are you talking
admiralty law and maritime?
But why are they operating in admiralty law? Why are they operating that way?
Because they're a rogue government.
Can I interject based on my comprehension? Right. So there are ministers, and we have to understand, right? Okay, so according to the 12 presumptions of court, everything is private until we make it public. That's one, right? So you got to know your position when you come in there. An administrator is always administering the assets or the trust that they're creating, which is a constructive trust, right? We
Yes.
know that they're already breaching the Constitution. They don't give a darn about none of that, and they are not following their oath of office at all. Even though the oath of office would say that they would discharge the debt of the public. However, if you're not appointing them or you can't hold them accountable to them, why would they do that, right? Everything is bonds, claims, and titles. So at the end of the day, right, it's like you have to know how to either hold them accountable verbally or just sue them. And it's just knowing how to do it, because the average person don't have $10,000 per occurrence for violating my rights. But you have to state a claim where relief could be granted and not walk in there just using the Constitution, because we are not a party to the Constitution. So it's just like one of those things you can go in there and talk that, but they don't give a damn about that.
Now hold on.
Why are you not?
Wait a minute. Hold on, Arnaz. We're going to keep order, y'all. That's one thing we are absolutely positively are going to have. The order is, I wanted to clarify. She said that we're not a party to the Constitution. What lawful document are you a party to? What lawful document can they hold against you or to you too? That is for League of Winners.
Okay, so any kind, one, not stating your position beforehand, right? Paperwork already preceding you, already rebutting the 12 presumptions.
Nope, League of Winners. I want answers. I don't want paperwork. When I ask you who you are, I want you to tell me who you are. Like, wait a minute, Arnaz. Because I need our people to understand. That's why the international law class on Tuesday is going to be very, very important, because Moors have a presumption. They're working off of a presumption that they are not under the jurisdiction of United States. International community already squashed that. And how did they squash that? We're going to talk about that in international law, but I want to give y'all and they did this in 1952, while we ain't really know about it. In 1952, when France took the United States of America to court, to the ICJ, the International Criminal Court, under the statutes of the United Nations, for a clarification in regards to the rights of United States citizens within Morocco. Now, Moors didn't come back to the table in their sovereign capacity by establishing a state for which they could come in there. So France was operating as the power of attorney to the Moors per the Treaty of Fez. Because the treaties is the only so-called laws that we can hold the United States or any other so-called nation to that's a party to that treaty. That's the only law we can do, because we have not established states until they started being established 2 years ago with the declaration of the first state down in Colorado. I don't want to get too far off of it. I want to stay in where we're supposed to stay in terms of what the international community is saying about rights of the United States and jurisdiction of the United States. We're going to get into that document. I'm going to put it on this site. There's probably going to be an international court section of the class assignments, but the courts have already said, international courts have already said, pursuant to the Treaty of Peace and Friendship, that the United States have temporary limited jurisdiction over Morocco because the Moors have not come back and reclaimed those seats. They didn't say it in that purview. They said, I quote, the United States of America has temporary limited jurisdiction. That's what limited means. It's limited and it is literally temporary over Moroccan subjects, proteges, those are because they already got jurisdiction over their own people. Moors are identified in that classification as Moorish subjects or proteges. And they didn't use Moorish, y'all, in the document. They just used proteges. Proteges are persons protected under the jurisdiction of another. So that's what all Moors are classified that don't have a status outside of that for which they've declared their independence and allegiance to, a Moroccan state. So when I ask you guys these questions, I'm asking them because I need you to understand that. We thought certain things, trust me, we thought certain things that we could just sit here and declare our nationality and we could hold them accountable. Well, we've tried that and we're still all fighting for the same thing we were fighting for 5 years ago. So I don't do the same thing. I don't push the same narrative. I go deeper. And when I was confronted with the information that we are going to discuss, I was like, okay, we got it now. Now we got to get everybody, all the other Moors that ain't got it, to get it. You understand what I'm saying, League of Winners?
Yeah.
So, and Arnaz, do you get what I'm saying? So you are subject to the jurisdiction. You do have to go to court. Because if you don't, you're gonna operate ex parte.
What I'm doing is working for me. Like today, I went to a court hearing and I entered my special appearance, which is already challenging jurisdiction. They ain't approach no bench. I ain't do none of that. He tried to proceed with the joint. He tried to proceed with the hearing. I already put my avertment of jurisdiction and writ of discovery in. I already questioned him for his delegation authority. He was so stuck and stupid, he got up and left without even excusing himself. Then he came back, said, well, we're going to have a hearing. Well, I said, well, I don't agree to this hearing. I haven't signed nothing or entered my signature on anything to be a part of this charade. And I walked out of there.
How long ago was that?
I just did that today.
Right. How many times have you had to do that for the same case?
Nah, they because
no.
they
How
don't
long
right
you been
now.
fighting this case?
Well, right now in my city, I have a target on me because they know I go in there and represent myself.
That's not my question.
They already threw me in jail. I had to get myself back out of there.
That's the point.
Yeah.
That is the point. The fact that one, you gotta go, and two, that they still have the authority to throw you in court. What I'm saying is, yes, you're standing on law and you're standing on the fact that you don't want to contract with them, but that's not doing away with the case. The case is still
that's the only piece I'm missing. I don't know.
It's not a piece that you're missing. It's not a piece you're missing. What they're saying is we're going to hold this charge against you until either you capitulate because you're tired of coming in here. So we're going, because we here Monday through Friday every week. Yeah. We got to be here. We don't care how many times we got to pull you in to come in here to answer for this. You understand what I'm saying? It's not about just having success on an individual level. It's about the fact that they can't even call you in there. It's about the facts. Once you say what you are, you're going to hand that off to different individuals at a different level, because Moors that have a political status, that have a state representation, are supposed to go any grievances, and that's treaty of peace and friendship, y'all. They're required to go to consular court if they got issues with Moors. They're not supposed to be calling you into their venue. So that's the point I'm trying to make to you, Arnaz. Did anybody else want to say something? Because I think somebody wanted to say something.
That was me.
I'm not sure who. Okay.
Islam. So you know, YeSharon's been with me through the gist of my fighting a case that I finally basically came to a compromise with. You know, more so because I just realized like everything that we're doing is facts, but you got to operate like that from the beginning, and there's things that need to be in place properly while you're fighting. So through that, I definitely learned a lot. And I can say that a lot of the documents that I start submitting, they start treating me different. When I say different, I mean like with respect.
There you go.
They started to address me different. They started to talk to me as if I existed. I noticed that once I told them what I was willing to take, that's what they agreed to, and they jumped up quickly. So that showed me a lot. Another thing, some things that I submitted in to the court, like the equity and notice of subrogation, it removed all my fines. It's so crazy because my case started as a criminal case for possession with intent to deliver. By the end of the prelim or pre-trial hearing, where we had the sentencing hearing, I got a notice in the mail and it turned into a civil judgment.
And that's the crazy part, because it was only a civil violation. It was a civil claim, because a felony is not, okay, even though that's only listed as a felony per their statute.
Right.
Because per international law and per their own constitution, a felony is a heinous crime. It's a violent, heinous crime.
And there was a hearing where I said that out loud into the court when I said, well, basically, you're putting a claim against my state for a felony, and I listed, but technically a felony according to the law are these things, and they got silent. But
yeah, because they're getting people to consent to be a felon, even though that's not a felon charge.
Right.
And then it'll be on your record as a felon, and then you got to deal with all this nonsense.
Like I said, this ain't my first rodeo with these type of charges. I've had other rodeos where, I was more ignorant. I wasn't privy to this knowledge.
Right.
I didn't know a lot of this at all, and I was younger, but the same charges, maybe lesser weight, which is really irrelevant. A felony's a felony. And I had an attorney, and not having an attorney this last hearing, I seen documents that I would never see had I went in by myself. Because these are documents that they give to attorneys to sign, and they never show them to you. And the reason is because you have them acting as your POA.
Yeah, power of attorney.
So they don't have to show you those because you agreed to let them sign on your behalf without you present. So I seen documents and I was like, whoa, I've been to court before. I've had charges before. I've never seen these documents, right? I've never seen a criminal case at the end of the order get a civil judgment from the prothonotary as a notice of record of judgment for a civil judgment, but it also said, but this is not a bill or a lawsuit. So I'm just saying, like, I learned a lot from submitting certain documents on the record and stating certain things in the court that it shakes them up a little bit, but they're never going to show us that they're in shambles.
Exactly.
They answer you silently through mail. Right.
And that's the part our people have to understand, Kimberly, is the fact that they've been just playing court with us this entire time.
Right.
Acting as if you did something, getting you to plead to a charge, and they're getting mad money and mad promotions because of these things, because assets is transferring.
Right. And I started reading like into the law heavier, like with even how stamps are used to discharge debts. And when I start responding like that, they start responding back like that. So they know.
But here's my issue.
They know about.
Here's my issue with trying to cancel. Why should we cancel a debt that's fraudulent? Why should we discharge something that should have never been charged?
Well, I think
so. A lot of times,
real quick, just to give an input to your question. So, I think it's not us canceling it. I think it's really us just at least doing those steps on the record to show how much fraud they've done. So when we do file these lawsuits, we have proof that really you guys know the whole time what you were doing. So the same way we keep submitting into their jurisdiction and playing their game, when we operate with our game and they start to answer it with those answers, then basically now we have more proof for when we do have lawsuits. Oh, but you responded like this, so you know.
But here's the thing, Kimberly.
Just something,
Here's the thing. I've been on many sides, right?
Right.
I don't want us to have to go into a court venue that is not a venue that we are supposed to be in. As soon as you said you got consular agents or consular notification and access, they're supposed to pump they hold brakes. That's the point. That's what we're working towards. Not sitting here filing paperwork within their jurisdictions as if they have rights over you, even though those rights are only based on the law.
Right.
But we've been capitulating for such a long time and just going in there, spending our time in their facilities. They getting paid for that, for you to be in that facility. Not only are they getting paid, you working in there, all types of different things, doing studies, all types of things are being done in these jails. So they're transferring wealth from you and your people to them. How are they doing it? They taking your property, they taking your houses, they might even be taking your children, putting them under some foster care programs. That's devastating. And that's also called genocide.
I got into it with a lawyer that stood up. I don't know if you guys heard about the Jim Rogers case that happened here in PA with the guy in my city, but the cops basically let him die in the back of the police car over a bicycle, and he was an older man. It was on video. So we went to a conference where they showed the video public. You know, I'm friends with some people that run organizations that fight for their laws or whatever. So we watched the video, and knowing some of the language I know now, when the attorney that was up there, this a civil rights attorney, stood up there and talked about how he was protecting the interest of the state, and he wouldn't form to the questions that the people were asking him, well, do you think the cops did something wrong? Will you charge the cops? And this was a Black attorney, and I'm gonna call him Black because that's what he act like. So he would not directly answer the questions, knowing that these cops were wrong, and it's blatantly on the video. And by the language he was speaking, from some of the language, you made a study out of the Black Laws Dictionary. Basically, really what he was saying is he got money off that estate. He won that lawsuit. So he was protecting the interests of that estate, literally, right? But to the general ears, they don't hear it how we hear it.
Of course.
I heard it differently. I understood it differently, right?
And just think about if that judge, if they got an attorney, the family got an attorney, obviously when the news like
it was worse than that. The attorney won $8 million.
How did the attorney won $8 million?
Listen, that's why I was in there, and I started.
Who bought the case?
The state. Him. Like, so look, the attorney won $8 million. It was allegedly paid out to the family members, right? But at this public hearing, the family members were there, and they're questioning him, well, where's this $8 million? Because we're the only immediate family he had. So there's stories going out saying that the names on the documents that were filed were just names that aren't of family members going up under some paperwork was filed, and that attorney fought that case. So that's what I'm saying. It was a lot of janky stuff.
Yeah, that was fraud. Because
exactly.
Because hold on 1 second. In order for that attorney to bring that case, right?
Right.
He would have to have power of attorney from the defendant who passed or the family members.
Right.
Because he has no interest or he's there, he's a trustee for that so-called deceased person, which I think he was not.
That's what I'm saying. He was not. He filed some type of papers because he knows this is a dead man now. His estate is wide open. Nobody.
It's not wide open. It automatically reverts to the family if they're smart enough to claim it.
But what I'm saying is they know 10 times out of 10 these people are not smart enough to claim it. They don't.
That's true.
But he does. So now these family members are here that are immediate, and he's not answering questions because they're like, well, where'd it go? Because he lived.
But here's the thing: what are they going to do to fix that? Because if there was a judgment on the case,
they're older. They don't know what to do. They're older. That's my
point. That's my point.
They need to bring a charge of like breach of fiduciary duties first and foremost, because we already know
about Black people.
We're talking about 80-year-old people that know nothing. This is
our elders don't know.
Wait a minute. So he doesn't have any children?
No.
He just got a mom and a dad?
And an uncle and aunt that he lived with all his life. Like, damn.
Oh yeah, they are the heirs. They are heirs to state. Because if there's no children for it to revert to, it automatically goes to the mom.
When it's time for the questions, he's like brushing the questions off. They're like, well,
all they gotta do is go hire an attorney. All they gotta do is go hire an attorney and figure out what's going on. But again, we're talking about attorneys, y'all. They all doing that.
They all doing it. And then he wouldn't, of course, he's not going to implement that the cops are guilty, because if you say they're guilty and they know you got some of that money, they're going to take you under with them. It's all them. They all got interest in that estate.
Mm-hmm. They all paid. He got it and he divvied it up.
There you go. So me knowing and learning what I learned, I was able to understand the language that he was using because he was very precise and particular about the way he responded to questions.
That's a very, very interesting case, and I'm glad you kind of stuck to it. But here's the thing.
And I made
it's
a
not
comment
about,
to
hold
him.
on, Kimberly, it's not about just having the cases. It's about putting the knowledge, putting the information out there. That's where the radio stations, the podcasts come out, because nobody's going to know these things are happening unless we have our own media. We need our media outlets to report certain things, so at least we know about it. Because that's how they know. That's how they know. They as soon as one of them, as soon as somebody saw that guy died in the back of the car, as soon as they said it, they pounced. I guarantee you.
Oh, well,
that's why they watch the news. That's literally why they read the paper.
Listen, so this happened over 2 years ago now. So
that was that long ago.
Right,
I thought you was talking about something recent.
No, so this is the other catch-22. Allegedly, he couldn't release the video to the public because he had to fight the federal courts. So he just won. But after the statute is up under their law, right? To where technically can't be a charge. For the people that only know statutory law. But on a federal scale, fraud don't have a limitation.
Well, so fraud don't have limitations on anything. Even at the stat level, you can't put no limitations on fraud.
Right.
And one thing I come across, like when it comes to evidence, like they even have like a statute that says that they have the right to destroy evidence. And it's like making sure that you ask and get all of that from the very beginning, because they will. Why would I not destroy it? Why would I not suppress it?
Right.
I think certain things, like even if they seize items, so say they seize personal property in connection to a claim, after the disposition of the case, it is your responsibility to request that evidence back.
Right.
If you don't, within 2 years, they can sell it. You know, they just making money front ways, back ways, sideways. They making cake on our people.
And can I interject? Everything that you just said keeps just showing that there's a trust relationship. And it's just like,
trust
okay,
relationship.
It's a custodian, this attorney and the lawyer is acting as a trustee, right? And then you're automatically saying that you're incompetent because you can't bring a claim that's thorough enough. And that's within the 12 presumptions of court. And like, I just stand on everything is that trust relationship. And at the end of the day, when you come into those venues, they're saying that they're the grantors and the beneficiaries. And we're the trustees not doing our job. So it's just holding everybody accountable to what is going on. And it's just like, you're not.
But think about it this way, League of Winners. Yes, they're the trustees, not because you've appointed them.
Exactly.
They're trustees because you're not handling your own affairs. Here's the thing. You can't handle your own affairs, even though there's a presumption in our community that you can. But those presumptions are blown out of the water because you're still capitulating in multitudes of ways. They're your trustee because you don't have state representation through your treaties by the establishment of states. So they're going to continue to be your trustee and manage things if you don't get in the game. Because all land within Morocco that is not declared by a Moroccan state is abandoned by why you think they're administrators?
Correct. And this is why I firmly stand on the fact of, like you said, until the Moroccan government is erected and it's acknowledged amongst everybody and we are in agreement with consular, you need to come from a trust position. You need to have your own and you need to have your trustees, and you have to come for that, because anything after that is like breach of trust, trespassing on trust property.
Oh my God, you gotta mute because you're just doing way too much over there in League of Winners. What's going on in the background?
I got a 1-year-old. He think that he can chef it up around here in these streets, and I'm just letting him rock out because that's kind of like what it is.
All right, well, mute your mic. Islam Moors, and without further ado, because we had a nice long jazz session. I call this the jazz session, where everybody gets to kind of talk about the things that they need to talk about. But at the end of the day, We have things to do, Moors, period. I watched a TikToker that said, our people have always been waiting for change, thinking that change is going to come by just the sheer time elapsing, that you're going to ultimately get to the finish line that you're seeking to get to. He says you're going to have pains, you're going to have disappointments, you're going to have bad people do things to you, you're going to lose your mom, you're going to lose your dad. He said the only way change is going to come is if you participate in that change, not just wait for it. You are putting things so it will happen. You are making moves so it will happen. So that's what I say to all Moors who talk about, securing their estate. Well, you do have an estate, but you're not claiming it because some other agency is claiming it on your behalf because you haven't put a legitimate, competent claim for which remedy can be sought, right? So we Moors are sitting here within that jurisdiction doing all types of things that I'm not saying that you're supposed to stop doing those things. I'm saying they are Band-Aids covering a gaping wound. It's only one way to stop that bleeding, y'all, and that hemorrhaging, y'all. You got to sew it up. You got to actually put something in place to heal it, not something that's just gonna plug a pipe. That's what nationality is. That's what getting to the international court and doing our due diligence as states being established to come to a resolve, to get them to stop doing what they are doing. Not only to get it, we just had a recent international case that came up to the ICJ, the International Criminal Court, was South Africa versus Israel, and it was a case for genocide. They wanted some assistance to assist or to sanction or at least to advise Israel to stop genociding the people down there in the Gaza Strip. That's the way nations and other nations come together to put sanctions on a nation that is violating. But before you can put a sanction on them, there has to be things done. So that means you gotta declare a state based on the current norms of international law. Well, all the 4 treaties that I've been talking about for the past 1.5 to 2 years gives us the blueprint on establishing those states. Treaty of Peace and Friendship, Treaty of Madrid, Treaty of Algiers, and the Treaty of Fez, and the Treaty of Madrid. All of these treaties are which are our treaties, tell the Moors what they're supposed to do. So why are the Moors the only one not using the treaties to form states, to come into alignment? And when we learn that we need to course correct, why we fight against knowledge and truth? That's things we need to think about, because there's so many Moors who are still on the same freaking road. That road has already proven to be a waste of time. You're going to keep going down the road, stopping off at the UCCs, stopping off at the secure party creditors, stopping off at the LLCs, getting all of these, wasting a lot of time and giving all of these different processes to stop a gaping wound. You might be able to bandage it up, but you're gonna keep redressing it, because a lot of the things that you are participating in now was never meant for our people to be a beneficiary within that organization. We are the oil that keeps the wheels turning. So we are the energy. So we just have to make a decision to say, I'm going to stop being against the tide and go with the tide. There's 182, last time I heard, I don't even know how many it is, but I'm just going to throw a number out there. 182 nations. 182 nations were created so they could create and instill and make sure they got peace. Make sure, or at least start the process of renegotiating contracts, renegotiating partnerships, renegotiating treaty rights. But if we're not willing to go to the table, do we really have a right to complain? And I'm not about being insane and doing the same thing for 20, 30 years, expecting a different result, but yet you're still having the same result. So my question again, who started homework? Anybody? Come on, y'all, unmute your mics. Who started homework?
No registration, no tags.
I just went and got mine.
You just went and print yours out?
You know I did. I sent it to you.
I know. That's what I was telling them earlier. I was like, yeah, I had one person screenshot me that he printed them all out. And that is good because let me tell you, this is gonna this one little document coupled with the rules of civil court. So you got the rules of court for that particular territory that you domicile in. So you can make sure they can't try to keep stalling you. They can't try, they stop with all of the postponements because they're postponing it because you're not ready. Or they're trying to distract, right? So I always say, well, you got to meet fire with fire. They're putting lawsuits against you, which is called so-called tickets, violations, and trying to get you to financially pay for them. Why aren't you asking for a remedy? Because like I said, like I tell everybody, racial profiling is an imagination. They're messing with you because you don't know the law. And that you'll give them everything just to stay out of jail and not realize that if our people, and I'm talking about our previous generation, my mom and my dad, your mom and your dad, taught us the things that we needed to be taught, we would not still at this juncture have 18, 17, 19-year-olds being profiled out there, people dying out there, not a political base out there. So we got to realize, just like I said earlier, you can't keep kicking the bucket down the street. And if you're not willing to do anything to change anything, change ain't going to happen. It's actually going to happen in the reverse. So however bad it is, it's going to get worse. And I think we're at the worst junction. I'm just going to tell y'all. So without further ado, does anybody have any questions about chapter 1 and chapter 2 in terms of false imprisonment? Last class, we read chapter 1, which was introduction. And like I say, I recommend everybody download the document because chapter 1 was literally a page. Chapter 1 is literally a page. So I'm opening it up to the floor. If I don't have anybody who actually did, then I'm going to start reading. I'm just going to go quickly over the introduction. Y'all read it at y'all leisure. But I'm just going to go over specific facts that are expressed in there. And then maybe we'll go over the class 1 assignments. Fair enough? Islam. So if you just click on this document, it's going to take you right to the treatise on arrest and false imprisonment. Okay, it's a book illustrated or established by Charles A. Wiseman back in 1993 was the first copyright. And here's the table of contents. The table of contents will let you jump all over this place. So don't, if you have a copy of it, let you jump all over. So you can go just jump right to the spot that you're looking at or the information that you need. Islam. So as we go down to the introduction, it just talks about what is this book about? It's about your liberty. This book is about liberty, and it's about lawful and unlawful means by which government acts in depriving an individual of his liberty. History teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. And because they've been getting away with it, because people have not been holding them accountable, they're going to keep doing it. The contest for the ages has been to rescue liberty from the grasp of the executive power. Why do they have a hold on liberty? Because the people have not been doing their due diligence. So we would like to blame government for its employees, but the people also have a part to play in that because They don't know the laws for which they are being held accountable, or arguments or defenses against a arbitrary conviction, or you being pulled into their courts and now you're being held without bail, and you don't got nobody out here that know a damn thing. So in most of these cases, as well as constantly, like the gentleman said earlier, he's got to keep going back and forth. Like, who has time? That's money. Keep going back and forth to sit in front of somebody who never had the authority for you. If you knew that they didn't have any authority and they couldn't pull you in there, you wouldn't go. So you're only capitulating even to participate, whether it's a special appearance, because of the fear of them coming to get you, right? So liberty is taken away or deprived most commonly by arrest or imprisonment. And like I said earlier, the consequences of these things happening are devastating on the people. People lose jobs for being detained for 2 to 3 to 4 to 5 days. The practice of easy arrest and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills, which turn out thousands of new laws every year. Well, a law that is contrary to the Constitution for the state as well as to the Fed level is a statutory regulation. It's a recommendation. It's private law, not public law. The passion of modern legislatures to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or a summons. But it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of the laws. Well, he's doing that already by pulling people in, questioning them, holding them for hours, and then letting them go. Well, that was a violation from the beginning all the way up to the end. And because most people don't know that, they don't do nothing. And because they don't do nothing, they keep doing it. It's like a child that doesn't get beat or doesn't get disciplined when he misbehaves. Well, what's going to be the reason for him to not continue that behavior? He's going to continue misbehaving because there's no consequences for it. No one can be saved to leave their home or to travel about for fear of being subject to thousands of unknown laws in which he could be constantly arrested for transgressing. One law review writer states the problem as follows. People no longer live their whole lives in the village in which they were born. That is completely true. They pass freely from place to place and in transit go through innumerable towns and villages. The risk of being arrested on sight because one's conduct contravenes some regulation which the wisdom of the local saloons deems necessary is appalling to any thinking person. It would be impossible to know at what moment one might become amenable to arrest. The next section talks about the revolution in England and all as well as America, because the same thing that they're doing to us was done to them in England under the king, which is why so-called Americans fought against England. So they could have decisions and they could have liberties, but more importantly, so they could have redress for injuries inflicted upon them outside of law, right? So to go down to the last sentence in that paragraph, the executive power is limited and guided by the law of the land, which is also known as due process of law. If it was a restriction upon the King of England, it might so far every petty officers today, right? So in many of the treatises on the law pertaining to the rights of citizens, and in many of the older and better court cases, we find the Declaration. The law is very jealous of the liberties of the citizens, right? What law is What law is it that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his own peril. This law also prescribes how arrests are to be made and the restrictions involved. And then you got 2 court cases that are underneath it under case references in chapter 1. And then we have the definitions for those terms that I highlighted in that chapter. So the definitions we have is arrest, imprisonment, despotic, legislature, warrant, summons, authorized, trespassing, and treaty. Those definitions are listed or are at the bottom. So you can complete those at your leisure, right? So without going through those particular definitions, because that is a part of your homework, and it is best to use a Black's Law Dictionary when defining these terms. And if you don't have a Black's Law Dictionary, you can always go on the website under the erudite lessons, and those and a copy of a PDF version of the Black's Law can be printed out, y'all. Okay. So the first question in this section is, what are the most common ways liberties are taken away from the people? That is open to the floor. Islam. John, I see it. Islam, Razim, welcome. Missed you much too.
Same here. Islam, everyone. Peace and love. The answer to number 1 would be liberty is taken away or deprived most commonly by arrest and imprisonment.
Islam. That is the answer. That's on my answer sheet. Islam. Does anybody have, well, obviously that is taken from the course. Number 2 is, what is the executive power limited and guided by? So the question is, what is the executive power limited and guided by? That is open to the floor. Who has the answer to question number 2? Come on, Razine, I know you got it. Kimberly should have this one too. So should League of Winners. What's going on? Now go ahead.
You told me to mute my mic, but I would say the Constitution, and if not that, then it would be like the Bill of Rights and the Declaration
Bill of Rights is the
Independence.
Constitution, right? Those are 2 of the same document.
Okay.
Right? Because it's talking about how is the executive power limited and guided? And that was the best answer. The executive power is limited and guided by the laws of the land or the due process of law, which would be the Constitution for the state, as well as the Constitution for the federal level, as well as all treaties that have been ratified by the state or the country. Islam, any questions in regards to the first introduction chapter? Because that was quick and easy. And the next one is the awesome getting into the meat and potatoes. The next section is definitions of false imprisonment. So is there any questions or comments in regards to introduction chapter?
No.
Islam. Now, this next section is quite lengthy, okay? It's about 4 pages, and I am not going to be the only one reading. I just needed us to get past the open oral session of class to get participation, to make sure everybody's awake. And again, your definitions are here, but if you go all the way down to the end of this document, I don't even know if I can kind of jump down there to show you guys. All the definitions are here, and you complete them at your leisure, right? And we'll go over the definitions of tonight's class tomorrow. Next class. And we'll do it that way. So I know that you are at least doing it. Why is this here? Goodness. All right. So the next chapter is chapter 2. And it's on false imprisonment. And who would like to start reading? Islam, John Bay, please begin.
Islam, everybody. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar Henry de Braca, from 1200 to 1268, tells us that false imprisonment is one of the oldest violations of rights known. Forcefully to deprive a man of freedom to go wherever so he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. False imprisonment is classified as a tort under the common law and also as a crime. 2, it has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, given one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their personal property. A theft of liberty is a wrong by which remedy can be had, just as the case with the theft of a property. False imprisonment is a great offense due to high regard the law has for liberty. In Chile's practice of the law, it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed as false imprisonment or malicious prosecution. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on the hands is not necessary to constitute an unlawful detention. 4, the only essential element of the action of false imprisonment are detention or restraint against one's will, and the unlawfulness of such detention or restraints. 5, in his treatise of the law of torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing by force or threat an unlawful restraint upon a man's freedom of locomotion. 6, Blackstone, in his commentaries on the law, 3BL, I think that's Black's Law, or I don't know what that is, 127, states on the matter, every confinement of the person is an imprisonment, whether it be common prison or in a private house or in a stock, or even by forcibly detaining one in the public streets. Thus, any type of detainment or confinement of a person or restriction of deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment,
Islam, stop right there. Stop right there. Thank you for that. I wanted to kind of highlight false imprisonment.
That's
when we talk, and it is, and you're gonna realize just how much we've been violated by just this treaty alone. And then you compare it to the state regulations and then the state acts and see what conditions need to be met. So what they're trying to tell you is, in order to file a false imprisonment tort claim for remedy against this false imprisonment, only 2 elements have to be met. You had to be detained against your will, so you didn't consent to it, and it had to be unlawful. Those are the only two things that you must show in your tort claim. One of the things that our people like to get involved in is arguing it, like arguing or defending against the actual case. That's not what a tort claim is. It's a civil claim, and the only thing that you need to do is, one, file it, and two, make sure these elements are present. So you had to be held. You had to be held against your will, and it had to be unlawful. Go ahead, legal winners.
So as far as with this tort claim, I've done research and I realized that there's like city torts, county torts, state tort, federal tort. Which area would you go for?
District. I would do it in district.
So district would be the county tort, state tort.
It would be the state court, yeah. That's where you would initially file this. That's where I would file it. And it depends on how much you're seeking too, remedy.
Correct, always, yeah, absolutely. All right.
Islam? So that's the first two levels, right? So I don't want to jump too far, because the first thing you got to do is, well, what happened? So you only got to explain just that much, because again, you're not arguing it and you're not defending. You're just stating the claim. Because a lot of times you think you got to be, you think you're arguing the case, and you're not arguing it. You're stating the claim, which is level 1 to the action. Is just stating the facts that you feel represent you've been falsely imprisoned, for which remedy needs to be sought. Islam?
Islam.
So then who's going to read next? Oops. Any volunteers? No? Everybody just want to listen?
I read. Where you at?
Wait a minute. Who just said that they would read? Was that Razine or Arnaz?
Yes.
Okay, Arnaz. Arnaz, you can go, and then Razine, you can go next.
Yes, we're at false imprisonment.
You're in describing false imprisonment. It's on the screen. Can you see screen?
Okay. Yeah. In describing false imprisonment as being the unlawful restraint of a liberty of the citizen, or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is in any restraint of the personal liberty of another, and the prevention of his movements from place to place, or his free action according to his own pleasure and will. It is a false imprisonment when this is done without lawful authority. In reviewing several textbooks, definitions of false imprisonment, the Supreme Court of North Carolina stated, false imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. A rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone, or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within the walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed within malice or ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause, therefore, and by words or acts which he fears to disregard. Keep going?
Yep.
Hold on. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience needs to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment.
I'm sorry.
False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrongful committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definition of false imprisonment usually comes from unlawful restraints of this nature. False imprisonment has been well defined to be a trespass committed by one man against the person of another by unlawful arresting him and detaining him without any legal authority. The law sets a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is estimated a great provocation. Oh, yeah, I said that right. All the authorities agrees that that's provocation. Provocation. All the authorities agrees that an arrest may be made either with or without any physical force or actual touching by the officer. Thus, any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint, prima facie. Any restraint put but by fear or force is unlawful. False imprisonment is necessarily a wrong interference with the personal liberty of an individual, usually made by an arrest. In physical custody or restraint is not essential to the effectuation of an arrest. So an officer tells a person that he is under arrest, he thereupon submits himself to the officer, going with him and obeying his orders. Such person is deprived of his liberty. And if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intention of the parties to the transaction or to be considered, in such a case, there must have been intent on the part of one of them to arrest or restrain the other, an intent on the part of such other to submit under the belief and impression that submission was necessary. The following definition will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another. And as here used, the word false seems to be symptoms with unlawful.
I'm sorry, I didn't. Go ahead.
Man, go ahead. Oh, you still want me to go?
Oh no, you could go. You could switch off to Razim.
Okay. Islam. Any exercise of force or expressed or implied threat of force by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant or a warrant illegally executed. Any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. Length and time requirement. The tort or wrong of false imprisonment occurs the instant that one is restrained in the exercise of their liberty. There is no unreasonable length of time for restraint before the tort can be claimed. False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any time whereby he is deprived of his personal liberty. Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment, even though the person was in the police car for less than a minute. It was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. Where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time duration is not a factor in making an arrest. False imprisonment is defined as an act which directly or indirectly is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration, makes the actor liable to the other. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time, and thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, the person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at common law, and relief by the party aggrieved was obtained by an action for trespass via armis, with force and arms. The illegal arrest of a person without a warrant or under an invalid warrant entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did. In Murphy versus Countess 1 Harris Dell 143, in an action for trespass, assault, and battery, and false imprisonment, the court held that the plaintiff could recover not merely for the time the constable was bringing him to jail, but for the whole period of his imprisonment. And in Mandeville versus Guernsey, 51 Barb, New York, 99, the court said, the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which resulted directly from the wrongful acts. Unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent, and absolute rights, which damages results as a legal consequence. A false imprisonment generally includes an assault and battery, and always at least a technical assault. An unlawful arrest, imprisonment, and prosecution of a person can cause that person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. Highlight that. Upon the subjects of damages, the law specifies two kinds of damages or divides them into two classes. There are what are called actual damages. Then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none are intended. In a false imprisonment, they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are also called compensatory damages, as they compensate the injured party for the actual injury sustained and no more. Punitive damages. Punitive damages are those that grow out of the wantonness or atrocity or aggravated by the act. They are the injuries and sufferings that were intended or occurred through malice, carelessness, or negligence, amounting to a wrong so reckless and wanton as to be without excuse. These are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for the damages caused. Thus, where a man was illegally arrested by a police officer and was placed in a patrol wagon in which he was taken to the central station, it was held that the two officers in charge of the patrol wagon were liable along with the arresting officer for false imprisonment. Malicious prosecution. In many cases of imprisonment or wrongful arrest, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have approximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and with malice. In an action of this type, the burden rests upon the plaintiff, the one bringing the suit, to establish each and all of the following propositions before being entitled to recover, to wit: one, he was prosecuted in a criminal proceeding or civil suit. 2, defendant instigated such prosecution. 3, the prosecution terminated favorable to the accused. 4, defendant acted without probable cause. 5, defendant acted with malice. And 6, damages that were caused. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail, and without any charge preferred against him. The defendants insisted his complaint was bad, as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There's a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial without legal process, it is false imprisonment. An arrest or imprisonment can be malicious or false, but not both. In a case of malicious prosecution, the arrest or detention is procured from malicious motives and without probable cause, but was done under unlawful process. Whereas in false imprisonment, the detention is without proper legal authority. One may be legally arrested for some alleged reason, but done maliciously. If he is found to be not guilty, he then has a case for malicious prosecution, but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not, he has a case for false imprisonment, but not malicious prosecution. If this is done with malice, it will add punitive damages to the suit. In describing the distinction between these two charges, Supreme Court of Oregon stated that foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may have sustained when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. In other words, the want of authority is an essential element in action for false imprisonment, whereas malice and the want of probable cause are the essentials in an action for malicious prosecution. Somewhat different to the wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose, in which malice or ill will may also be a factor. In which malice or ill will may also be a factor. The term malicious arrest is used in some cases instead of malicious prosecution, but the latter is broader in scope. Should I read the case references?
Nope, you don't have to read the case references because, I mean, I'm going to show you. They're very long. These are all the cases that are quoted. And I made sure to put them in here because you might want to get further clarification on the difference between the two, as well as the section on the homework, which we're not going to particularly go over. What I wanted to talk about is, what did you get from the chapter? What are the essential things that you got from the chapter? Because I don't really want to go over these questions. I want you to answer them in your leisure. What did you get from chapter 2? Morse? Open mic time. Open mic time.
Everything that you need for you to state a claim when you file a tort, and ultimately, to sum it up, is kidnapping.
Yes, but the legal term is false imprisonment, right?
Right.
Any other questions?
I got from the chapter something I didn't realize before. That I have a claim also for malicious prosecution because in the case that I was drawing up my complaint for, I was arrested and the case was dismissed, right? But they also put an ad in the paper, which damaged my reputation and all that. The case was dismissed, so it damaged my reputation. The story is still in the paper if I look it up.
That's all.
Yeah.
And so, you would be able to, you would have multiple claims in your cause of action. And one of them would be defamation of character. And what's the other one? Yeah, defamation of character is one of them. But but you could put that particular case against the news people who created that article, who made that article in regards to your offense, because just because you might be charged with an offense doesn't make you guilty, right? And the question is, they say, oh, that's a freedom of speech. Well, you do have the right to say what you want to say. So this might be where they their defense is, well, the Constitution entitles me to freedom of speech. Yeah, you have the freedom of speaking to someone, but if your article has caused harm to someone just because they were just accused of it, and by you putting this in the paper and before this individual was actually sentenced and found guilty of a violation, well, you were defaming that person's character, and because of that monetary damages should be provided, as well as a retraction of that article or a added, reposting it and clearing up the facts, right? So absolutely. Now realize you can only do one or the other in terms of false imprisonment versus malicious prosecution. On one hand, you could do malicious prosecution, but malicious prosecution has to have one element that false imprisonment doesn't have. Does anybody remember what that was? What makes your case a malicious prosecution versus a false imprisonment?
Like not proving that the claim that's being brought against the individual.
Right. meaning that the case ended favorably to the one accused.
Yes, the
So they won the
prosecutor
case.
terminated favorably.
Right. It was terminated favorably, and that's the difference. So some people would probably try to add all of these things, but you either got to do false imprisonment or you do malicious prosecution. Don't do both in your argument. But in my case, because it's kind of just like if you go to court and you got charges against you and they talk about, oh, you got 17 charges, right? So they're putting as many charges as they can because they know some of those gonna get knocked off. Same too with your civil claim. Put as many that are relevant to what happened to you. So you'll start with false imprisonment. That's count 1. Count 2 would be an assault and battery. Count 3 would be a trespass. Count 4 would be a violation of due process of law. Count 5 would be color of law action. Count 6 could be deprivation of rights. You know what I'm saying? You could keep going. And then as you go in those all award you a specific amount, right? And then you got, well, how much damages am I seeking? Well, I'm seeking $1 million, even though I know the judge is going to probably cap it down to whatever it is the law says I can get for each violation, but I'm going to put it up here. Right? So you have to state a remedy. Because a lot of times people will file and they won't even have what they're asking for. Well, what are you asking for because you were falsely imprisoned? Well, I'm asking for 50,000, or I'm asking for 75,000, or I'm asking for $1 million because these policy enforcers, these employees need to feel the ramifications of their actions. And if you only give them a $10,000 fine or a $20,000 fine, well, their insurance might cover that. This is a systemic issue within our community because, you know, we don't hold these individuals accountable. They have an authority, they have a responsibility. They can't claim ignorance to the laws that they have taken oaths to. It's ignorant. You shouldn't be putting anybody on your in your company that don't know the law. And you should be quizzing them systematically to make sure they know the laws because you're going to be held for that. So false imprisonment is a very, very good remedy for our people when they've been violated, because in some of these cases, your cars will get towed. You might lose your apartment because you were held for a week or a month, or, you know, you got released on bail and then ultimately the case was dropped because you put the right argument and you submitted those motions to suppress. Or how about motion to dismiss? But you would have to suppress the evidence first, right? I'm doing a motion to suppress based on the constitutional violations. This is what happened. How do you prove it? Well, they don't have a warrant. I wasn't breaching the peace. You know, and it all depends on what they try to say as a reason and justification for the detainment. A lot of times I hear people say that, well, they started with, I asked them why I was being pulled over, and they said that, you know, you were bobbing and weaving in and out of traffic. That would be what they would try to use as a just cause for pulling you over, because they think that meets the breach of peace requirement. So the pullover is legitimate, because outside of those two factors, which you'll get probably in chapter 3, what are the two elements and what are the two things that they need, that they can only arrest? Make a lawful arrest without a warrant, because there's a such thing. There's two levels, two different standards: arrest without warrant and arrest with a warrant. So both things have different requirements. To arrest with a warrant, or to even get a warrant, you got to have probable cause. To arrest without a warrant, you have to witness a felony in action as well as witness a breach of the peace. And a breach of the peace is not necessarily a misdemeanor, and a misdemeanor is not necessarily a breach of the peace. So I'm going a little further because these are levels to your complaint. And you need to be conscious of all of these things when you're writing your documents. I've seen documents where people will say, they won't even say, I did not consent to this. Well, you're saying that something happened that there was false imprisonment, but you didn't even say that you were held against your will. And when asked if there was a warrant, if they had a warrant or probable cause, they didn't say anything. They might have said no, they might have said nothing, but you have to put that in as a fact. Because that's your argument. False imprisonment meaning they didn't have the authority to do it. They didn't have the lawful authority and they did it against your will. Well, you got to sit here and say that you didn't consent to it. Sometimes your case will be blown out because they'll be like, oh, they didn't meet the elements of false imprisonment. They never said that they never said that they didn't consent to stop, or they didn't consent to the detainment, or they didn't ask for a warrant. You got to literally say that in your brief. When I was unlawfully detained, I asked them why they were detaining me. I asked them, did they have a warrant? I asked them to see the warrant, and they ignored all of these things. That has to be in your presentment, right? So we're gonna learn how to draft that document up, and then hey, file it. And you have to have the actual arresting policy enforcer on there. So you got to know the levels. How many defendants are there? Well, the first defendant is the arresting officer, all the other officers who you might know that were there. And if you don't know everybody's name there, at least you should know who arrested you. Either by going on their websites to see and saying, yeah, I think it was that one. And you can't say, I think. You have to absolutely know. Because I think, hey, that gets thrown out automatically. That's not a positive ID. Like, yes, that individual is the one that arrested me. The individual, yes. You have to be, that is factual. Right? So not only should the arresting officer be added to that suit, who else should be added to the suit? Any other so-called policy enforcer that was also on scene that heightened your compliance, because now you got all these policy enforcers and they might have had their guns drawn. They might have pulled, it was an assault and battery because they pushed you on the ground and you got injuries, you got embarrassed. I mean, there's a lot of things that our people go through when they get detained. It is a very big event. And then you go sit in a jail for like a day or 2 days, or they lose you for like a week. Right? Because misdemeanors are not an arrestable offense. So why are you getting detained? And how after the fact they might search your vehicle and then find a so-called firearm, or they might find some weed, or they might find something else. And now you got a charge. And you didn't say, well, I did not give them consent to search my vehicle. I asked for a warrant. No warrant was provided. That's the language. Stating exactly what happened. Any questions? Because we got 2 minutes. 7 minutes. Because we're going to end at 8:30. We started promptly at 6:30. So this was a 2-hour class. And I don't like to take advantage of people's time. And I don't like nobody taking advantage of my time, because this is a lot of energy, because your brains are expanding. Your brains are expanding with the information that you're gaining. And as long as you study and you put your little outline in, what are the elements of false imprisonment? What constitutes an assault and battery? What's a trespass? Those are your first 4 actions. But before you get to your actions, you state what happened. So you state what happened and making sure you're putting enough information in there, because the thing that so-called judge is going to be looking at, as well as that opposing those defendants, is if what you're saying meets what you're claiming. So now they're going to scuffle like, well, shucks, we got to figure out how we going to legitimize what the fuck we did to this girl or this guy. But evidence is evidence. If you had lawful authority, you will have a warrant. And the same thing could be used in the case that you're defending, right? This is a civil case we're talking about that you're filing against the policy enforcers. Now you rolled over and realized you were falsely imprisoned because what happened to you met these elements. Well, now you put a motion to suppress the evidence that was brought up against you because they searched you illegally. They didn't get your consent. They didn't have a warrant. So everything that was pulled in has to be thrown out. And by pulling it in and throwing it out, guess what happens? They got to dismiss the case because the evidence just got thrown out. And then you put your motion to dismiss. And now you can kick your claim up or revise your claim from false imprisonment to malicious prosecution. How can it not be malicious? They're going to act like they don't know the law. They're going to act like they don't know how to detain or interface with people when they don't have authority. You're going to tell me they've been on the police force for 10, 20, 50 fucking years and they don't know how to arrest or what law they be violating when they violate you? Come on. And then if you really on your game, go look at their past lawsuits. Just go do a search. And you can bring that in, but like, look, he's been sued 12 times by different people. So apparently he ain't learned the first, second, third, or fourth time. I think you need to make an example. You know what I'm saying, Morris? I yield. Any questions? Last 4 minutes. Islam.
Islam, I just want to say that that's a good point that you just made about looking up their past cases and lawsuits, because you can show a pattern of incompetence and not malicious. Not doing their job correctly, and you could probably have them go through some type of training.
Yeah, that could be also part of what remedy.
Yeah.
Like I want them to go through training. I want them to go. I think, if you're going to be representing a so-called court, I think they should have to do 2 years of some type of the laws. I think they should have to go through some type of formal training. Maybe it's not college. Maybe go watch some videos. And then they sign off on those videos so they can't claim. So because you're suing them on a private capacity. You're not suing them in their official capacity. You're suing the actual, not unless you add the police department in as a defendant, right? Because their agents were the ones provoking. Islam, any questions? Got a quiet crowd here tonight. Quiet crowd.
Just taking it all in, that's all.
Islam. Well, let's just make sure next class, which will be on Thursday for this class, we might have a class on Tuesday that starts international law. Hopefully you'll all be in attendance, but I think I'm definitely going to do that class because we need to be competent Moors and we need to get on the international information to do those things. So that is probably, if it's not coming this Tuesday, it'll be coming next Tuesday, but I'm gonna try and target for this coming Tuesday, same time, same station, 6:30 to 8:30. And if there are no questions with the close of the class, then we'll always end with the Moorish prayer. Does anybody want to say the Moorish prayer before we exit out? And obviously donations are always welcome. We definitely need your donations to provide this lovely platform and this lovely service because it does cost money and it takes finances to build a nation. So definitely if you can, and if you don't mind donating to this platform, please do so by sending it to my Cash App. And I think everybody on this platform, what is going on with this page? What happened? What happened? It put a target. That is weird. What was that? I don't know what that was. Did y'all see that on my screen? So I'm just gonna put that in the chat. Does anybody know the Cash App for donations? Does anybody know? Does anybody know the Morris prayer? No? Come on, Rosine, I know you know it.
Islam, yes, I know it.
Come on, because
All right.
everybody else be acting like they sleepy.
All right, just wanted to allow someone else to participate to Islam. 5 on the left, 2 on the right. Allah, the Father of the universe, the Father of love, truth, peace, freedom, and justice. Allah is my protector, my guide, and my salvation, by night and by day, through his prophet, Noble Drew Ali. Amen.
Islam Wars. Islam. Well, that's the close of our class. I will be uploading this class to my YouTube channel, as well as replacing the old videos with the new videos on the class assignments. So those will be available to you. But hopefully I'll be able to upload it tonight or most likely tomorrow. But please take this time to do your definitions for chapters 1 and 2, because we will go over that for the starter class next week and then resume with chapters 3 and 4. Islam, peace and love. Y'all have a good night.
Islam.
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 Islam, y'all. Be safe out there.
Peace and love.